Now, it is very important when you receive a statutory demand that you do not ignore a statutory demand. Why? Because under the law, a debtor, a person owing money, is presumed to be unable to pay a debt if he does not comply or apply to set aside a statutory demand. What is set aside? Set aside means cancel. If someone issues you a statutory demand and you dispute the debt, you have to hire a lawyer. You can do it yourself. You have to hire a lawyer within 14 days of receiving the statutory demand to file a summons with the High Court to cancel the statutory demand. That's called setting aside. You have to have valid reasons, though. You cannot just cancel it for the sake of it. If after a statutory demand for payment has been served on the debtor and the debtor does not repay the debt within 21 days, and he does not apply to set aside the statutory demand within 14 days of being served, then the creditor, the person issuing the letter of the statutory demand, can take out a bankruptcy application against the debtor. If the debt is a court judgment, in particular a default judgment, you can watch one of my videos about default judgment. If the debt arises from a judgment, the court is not going to look behind the judgment, the merits of the judgment, because it has already been litigated or it's a default judgment. So the court, if the debt arises from a judgment, the court will just look at the judgment and